In the early 1960s, the Supreme Court established the principle of one person, one vote. But even when honoring this principle, state legislatures can draw districts that give more power to one political party over another, or to ensure that one racial group gets more or fewer representatives. This is called gerrymandering. The word first appeared in a political cartoon published by a Boston newspaper in 1812, when some thought the shape of a district that was redrawn by Massachusetts Governor Elbridge Gerry resembled a salamander, hence gerrymandering. In the 1990s, this became an issue in North Carolina when, in order to create an additional black majority district, a map was drawn that essentially followed a highway for 160 miles. It was specifically drawn to include more minority voters. Some claimed it was racial gerrymandering. Shaw versus Reno would decide the issue.
Hi, I'm Doug Ginsburg, and I'm a federal judge. The case of Shaw versus Reno explores the complex relationship between race and redistricting. The Voting Rights Act of 1965 has been interpreted to mean that electoral districts should not be drawn in a way that dilutes the voting power of a racial or ethnic minority. In 1992, U.S. Attorney General Janet Reno rejected North Carolina's congressional redistricting plan because it had only one black majority district. In response, and to create a second black majority district, the state submitted a revised plan, adding a very unusually shaped district, drawn to include more black voters. That unusual shape led to a lawsuit by a group of white voters, claiming its only purpose was to secure the election of additional black representatives. The key issue facing the court was, does North Carolina's redistricting plan violate the Equal Protection Clause of the 14th Amendment? The Equal Protection Clause says, no state shall deny to any person within its jurisdiction the equal protection of the laws. After oral arguments and deliberations, the justices voted 5-4 in favor of Shaw. Justice Sandra Day O'Connor wrote the opinion, in which 4 other justices joined, and 4 justices dissented. Justice O'Connor stated that while race may be considered in redistricting, it cannot be the only reason for drawing district lines. While the ruling didn't outlaw race-conscious redistricting, it did establish that such plans will be subject to strict scrutiny. Strict scrutiny requires that the state have a compelling governmental interest in the plan, and the plan must be narrowly tailored to achieve that end. A government policy or a law that restricts a fundamental right, such as the right to vote, is subject to strict scrutiny, and that is such a high bar that those policies and laws are often held unconstitutional.
Shaw versus Reno was decided in favor of Shaw by a 5-4 majority vote in 1993. The key principle was the Equal Protection Clause of the 14th Amendment. The court held that under the 14th Amendment's Equal Protection Clause, majority-minority districts created under the Voting Rights Act of 1965 may be constitutionally challenged by voters if race is the only factor used in creating the district.